The Employees' Compensation Act 1923, as amended through Ec Amendment Act 2017. 11. Medical examination. 1. Where an employee has given notice of an accident, he shall, if the employer, before the expiry of 3 days from the time at which service of the notice has been effected, offers to have him examined free of charge by a qualified medical practitioner, submit himself for such examination, and any employees who is in receipt of a half-monthly payment under this act shall, if so required, submit himself for such examination from time to time, provided that an employee shall not be required to submit himself for examination by a medical practitioner otherwise than in accordance with rules made under this act, or at more frequent intervals than may be prescribed. 2. If an employee, on being required to do so by the employer under subsection 1, or by the commissioner at any time, refuses to submit himself for examination by a qualified medical practitioner or in any way obstructs the same, his right to compensation shall be suspended during the continuance of such refusal or obstruction unless, in the case of refusal, he was prevented by any sufficient cause from so submitting himself. 3. If an employee, before the expiry of the period within which he is liable under subsection 1 to be required to submit himself for medical examination, voluntarily leaves without having been so examined the vicinity of the place in which he was employed, his right to compensation shall be suspended until he returns and offers himself for such examination. 4. Where an employee, whose right to compensation has been suspended under subsection 2, or subsection 3, dies without having submitted himself for medical examination as required by either of those subsections, the commissioner may, if he thinks fit, direct the payment of compensation to the dependents of the deceased employee. 5. Where under subsection 2, or subsection 3, a right to compensation is suspended, no compensation shall be payable in respect of the period of suspension, and, if the period of suspension commences before the expiry of the waiting period referred to in clause D of subsection 1 of section 4, the waiting period shall be increased by the period during which the suspension continues. 6. Where an injured employee has refused to be attended by a qualified medical practitioner whose services have been offered to him by the employer free of charge, or having accepted such offer has deliberately disregarded the instructions of such medical practitioner, then, if it is proved that the employee has not thereafter been regularly attended by a qualified medical practitioner, or having been so attended has deliberately failed to follow his instructions, and that such refusal, disregard or failure was unreasonable in the circumstances of the case, and that the injury has been aggravated thereby, the injury and resulting disablement shall be deemed to be of the same nature and duration as they might reasonably have been expected to be if the employee had been regularly attended by a qualified medical practitioner whose instructions he had followed, and compensation, if any, shall be payable accordingly. 12. Contracting. 1. Where any person, hereinafter in this section referred to as the principal, in the course of or for the purposes of his trade or business contracts with any other person, hereinafter in this section referred to as the contractor, for the execution by or under the contractor of the whole or any part of any work which is ordinarily part of the trade or business of the principal shall be liable to pay to any employee employed in the execution of the work any compensation which he would have been liable to pay if that employee had been immediately employed by him. And where compensation is claimed from the principal, this act shall apply as if references to the principal were substituted for references to the employer, except that the amount of compensation shall be calculated with reference to the wages of the employee under the employer by whom he is immediately employed. 2. Where the principal is liable to pay compensation under this section, he shall be entitled to be indemnified by the contractor, or any other person from whom the employee could have recovered compensation, and where a contractor who is himself a principal is liable to pay compensation or to indemnify a principal under this section, he shall be entitled to be indemnified by any person standing to him in the relation of a contractor from whom the employee could have recovered compensation, and all questions as to the right to and the amount of any such indemnity shall, in default of agreement, be settled by the commissioner. 3. Nothing in this section shall be construed as preventing an employee from recovering compensation from the contractor instead of the principal. 4. This section shall not apply in any case where the accident occurred elsewhere than on, in or about the premises on which the principal has undertaken or usually undertakes, as the case may be, to execute the work or which are otherwise under his control or management. 13. Remedies of employer against stranger. Where an employee has recovered compensation in respect of any injury caused under circumstances creating a legal liability of some person other than the person by whom the compensation was paid to pay damages in respect thereof, the person by whom the compensation was paid and any person who has been called on to pay an indemnity under Section 12 shall be entitled to be indemnified by the person so liable to pay damages as aforesaid.